The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome to the North Carolina Court of Appeals. I'm Judge Valerie Zachary. Serving with me on this panel today are Judge Phil Berger and Judge Chris Brook. Assisting us today are Attorney Jean Soar with the Office of the Clerk of the Court of Appeals and Fred Wood, the Supreme Court Director of IT. Pursuant to the directives of the Chief Justice, we are live streaming this session of the court as we work remotely during the COVID-19 pandemic. Although we cannot currently invite members of the public to our courtroom in Raleigh, we are happy to welcome everyone to our virtual courtroom in the spirit of our tradition of publicly held proceedings. First on the calendar this morning is the case of State versus Michael Shane Falls from Gaston County. Another oral argument is scheduled to begin approximately 10 minutes after the completion of oral arguments in this matter. If counsel in the Falls case are ready, let's proceed. Each of you will have 30 minutes for your argument, and of course, the appellant will argue first. Ms. Hitchcock, would you like to reserve time for rebuttal?
Yes, Your Honor. Thank you. 5 minutes or any time that I have left.
Okay, that'd be fine.
May it please the court. Good morning, Your Honors. I'm Assistant Appellate Defender Mandy Hitchcock, and I represent Mr. Falls in this appeal. Your Honors, at 9:30 p.m. on a cold December night, 3 uniformed police officers cut through the dark trees in Mr. Falls' front yard, emerged from that dark with flashlights shining at him, and surrounded his car as he was backing out of his driveway to leave. In doing so, they violated Mr. Falls' Fourth Amendment right against an unreasonable search, and his motion to suppress should have been granted. Your Honors, in Florida v. Jardine, the United States Supreme Court held that the police investigation there was effected through an unlicensed physical intrusion. That is, the court held that Mr. Jardine had given the police no invitation, implied or otherwise, to do what they were doing on his front porch. This case presents this court with the same question, that whether or not the police here did something that Mr. Falls had made no invitation to them to do, implied or otherwise. And I ask this court to hold the same, that this investigation was effected through an unlicensed physical intrusion, and that Mr. Falls' motion to suppress should have been granted. As Your Honors know, for Fourth Amendment purposes, the home is the first among equals. And under the Fourth Amendment, the curtilage is part of the home. When police enter the curtilage to acquire information, a Fourth Amendment search occurs. This search is presumptively unreasonable if the police don't have a warrant. There are exceptions, but those exceptions are narrowly drawn and they are zealously guarded. One such exception is a knock and talk, where the police have the same implied license to do what any member of the public can do, which is approach via the front path, knock on the front door, and wait briefly to be received. What occurred here, Your Honors, was not a knock and talk. It was a warrantless search. First of all, Your Honors, the approach that the police took exceeded the scope of any concept of the implied license that is offered to the public. They did not take the path of a reasonably respectful guest. Justice Scalia gave a very helpful analogy here in the opinion in Jardine. He said, to find a visitor knocking on your door is routine, even if it's sometimes unwelcome. But to spot the same visitor exploring your front path with a metal detector or marching his bloodhound into the garden before saying hello and asking permission would inspire most of us to call the police.
Well, Ms. Hitchcock, let me stop you there.
Yes, Your Honor.
Because there's no metal detector or canine unit here. Let's say we've got someone who is interested in pressure washing a home. And he goes to the house. The homeowner that he wants to speak with is standing outside next to his vehicle. Can the pressure washer approach the homeowner at that point?
Your Honor, if the homeowner is standing outside his vehicle on his driveway, I think an implied license would allow that person to approach and say, would you be interested in having me pressure wash your house? And that would, of course, also depend on what time of day it was. I think the implied license really does depend on the totality of the circumstances, but that isn't what happened here.
Let me ask you a question there. How likely is it that a pressure washer who's interested in washing your house is going to show up in the middle of December on a Saturday evening at 9:30 at night? And then related to that question, is your argument that there can't be a knock and talk that occurs on a Saturday evening at 9:30? Is that you filed a supplemental authority from the Supreme Court of Michigan, which found that essentially, I read the case said that, it's not a knock and talk to show up at 4 a.m. It's not a knock and talk to show up at 5:30 a.m. Unanimously held that. So first, is a pressure washer going to show up Saturday at 9:30 p.m.? And is there any such thing as a knock and talk that can occur Saturday at 9:30 p.m.? Are you asking us to adopt essentially what I appreciate as the Michigan Supreme Court's rule here?
Your Honor, so I would say I don't think that a pressure washer would show up to offer to pressure wash your house at 9:30 p.m. in the middle of December. Certainly not. And the Supreme Court has made it clear that the implied invitation has the scope is based on time, place, meaning the way that they have approached your house, and also the purpose for which they approach your house. So that there is certainly I don't think there's any implied license for a pressure washer to approach the home at 9:30 p.m. on a Saturday night, nor would any homeowner expect someone to do that at 9:30 on a Saturday night.
Well, Ms. Hitchcock, let me stop you there. Okay, let's say it's not a pressure washer. Let's say UPS has a delivery in the middle of December at 9:30 at night, near Christmas, and as they approach the residence, they see an individual they believe to be the homeowner with the car lights on, sitting in or near the driveway. They need a signature to drop off this package. Can they approach the homeowner without first going to the door to knock?
Yes, Your Honor, because again, the scope of the implied license is time, place, and purpose. And so in this case, a homeowner who is having a UPS delivery done has invited UPS to come onto the property.
It's a gift. Maybe they haven't invited them. Maybe it's a gift from someone they weren't expecting. And, late at night, trying to get the delivery done.
Yes, Your Honor. I would say in that case, because their purpose is to make a delivery to the homeowner, there is an implied license for a UPS delivery driver to do that, even at that time, I would say, especially as we, again, circumstances are important here. It would, I would say in that particular case, yes. But that's not what happened here, though, Your Honor. What happened here is the police came out of Mr. Fall's yard and they surrounded his vehicle as he was trying to depart. That's another important piece of information that we need to consider here.
Well, why do you say the vehicle was surrounded?
Well, because, Your Honor, Officer Belton and Officer Paget approached him on the left side of the driver's side of the car, and Officer Hoyle walked around to the right side of the car and immediately began shining his flashlight into the vehicle. I don't think any reasonable person in the circumstances there would think they could just continue to back out while officers were on both sides of their car. I mean, he was effectively seized at that point by those officers. So
I presume that to use this UPS package delivery example, the UPS package delivery folks, certainly have an implied license to leave something on your front door. They perhaps, to Judge Berger's example, have an implied license to interact with you in your driveway and see if you'll sign something if they need a signature. Does a UPS package deliverer have the implied license to stop, surround your car?
Well, Your Honor,
when you're trying to depart, to stop a car that's trying to back out of a driveway.
So, Your Honor, can everyone still hear me?
Yes.
Okay, sorry, my video is freezing a little bit, so I just wanted to be sure. Okay. So again, Your Honor, in that particular case, I would say no. I think the UPS driver would have license to probably say, hi, I have a delivery for you. I need a signature. Are you okay to do it now? And give the person the opportunity to decide whether, yes, I want to go ahead and get this done so that I can get my package, or say no, in which case if the UPS delivery driver has to have a signature, then he'll have to return, because that's what's required. Your Honor, Judge Brooke, to go back to your question about whether we're asking this court to adopt the Michigan rule in this case, again, I think what the Supreme Court in Michigan was saying there is that to knock on the door of a homeowner at 4 o'clock in the morning or 5 o'clock in the morning is a trespass. And if that trespass was effected for the purpose of acquiring information, then a Fourth Amendment violation has occurred. And so the part of that case that I thought was important is that the Michigan Supreme Court actually recognized there that cutting across a homeowner's yard is a trespass. It is a trespass. The curtilage is the curtilage, and the protection of the curtilage is coextensive to the protection of the home. There's no de minimis.
And to that point, it's certainly not the way we would expect UPS to deliver a package, or Girl Scouts to come to sell you Girl Scout cookies, is not by emerging swiftly in a trio out of the woods at the side of your house, walking across your front yard swiftly at 9:30 at night. That would be unexpected. And to footnote 2 from Justice Scalia's opinion in Jardines, it would be both atypical but also alarming, it seems.
Correct, Your Honor. And even in a daytime hour, there was uniform agreement in this hearing that the typical path that a person would take, whether they were the mail carrier, a door-to-door seller, a FedEx delivery driver, would be to enter through the driveway, walk up to the sidewalk, and approach the front door. That is what everyone agreed. Even the trial court said it seems that would be the typical path to the door. That is the beginning and the end of the implied license in Mr. Fall's yard. There's no implied license for anyone to cut across the yard, whether it was in the daytime or at 9:30 at night.
Is your position that the officers were required to stay on the road and on the driveway and then go directly to the front door under these circumstances?
Yes, Your Honor.
Yes. If the officers went to the driveway first and approached the car, would there be an issue in this case?
Yes, Your Honor. There still would be an issue in this case. There is no implied invitation to anyone to surround a car that is attempting to back out of its driveway. A Girl Scout would not do that. If a driver was leaving the driveway and they wanted to sell cookies, they would not have an implied invitation to stop that person, look into the window and say, hi, I want to sell some cookies. Would you like to buy some?
What show of authority did the officers engage in here that would alert someone they were police officers?
Well, they were uniformed. They were armed. There were 3 of them together. They had flashlights, and I think as soon as Mr. Falls was able to actually see, he would have known that all 3 were police officers immediately.
But there was no show of authority other than them approaching with a flashlight. How is that a show of authority?
Well, Your Honor, again, it's from the perspective of the person. And I think any reasonable person in Mr. Falls' situation who is in the privacy of his own driveway, sitting in his car trying to leave, and is approached by 3 uniformed armed police officers, one of whom goes to the other side of his car, I think would experience that as a show of authority and understand that they are not at liberty to just continue to reverse and ignore the police in that situation.
So what if the officers had approached the driveway and as they approached the driveway, instead of 15 feet, 20 feet, they placed 1 foot on the grass between the road and the driveway to approach? Would that somehow invalidate a license to approach?
Well, Your Honor, in that situation, I'm not sure if you're saying they unintentionally stepped onto the property line. Where they approached was along the right of way. Mr. Fall's home is on a highway, so he does not have a sidewalk. They approached along the right of way because they chose to park in a parking lot of a church that was it is next door to Mr. Fall's home, and it's clearly demarcated the line between the church and Mr. Fall's yard. There on the body cam, you can clearly see they sort of go around some trees and through the sign by the church, and they approach that way. Now, if they, just incidentally stepped onto his property, then no, I would not say that that would be a violation of the implied license, because they were still trying to attempt to take the path that a reasonably respectful uninvited guest would do, which is to go to the driveway, walk up the driveway, and go to the sidewalk and knock on the front door. But as Officer Paget himself said, most people would probably just park in the driveway and walk up to the front door.
And in fact, those are sort of the facts of Grice, because I know Grice comes up during the course of briefing. My understanding of Grice is that the officers, in executing the knock and talk in that situation, drive up the driveway, park behind the vehicle. The front door is inaccessible, so they go to what they believe is the main door, the side door, and they knock on that door. So the officers, obviously Judge Berger raises a good point, which is that this is something of a challenging circumstance given that they parked in the church parking lot, because it's a highway, as you referenced, and we are obviously solicitous and care about officer safety here. But as in Grice, there was another way to handle this, which was to park in, pull into the driveway and walk up the path that was, as I believe Officer Paget said, the way that the Girl Scouts would approach the house, right?
Yes, Your Honor. Yes, Your Honor. And the trial court was clear about that there is a very clearly marked front path, sidewalk that goes from the driveway. But for some reason, the trial court also found that there was a path through the front yard that was not obvious. And there's just no evidence that supports that. All the officers said there was no path through the front yard at all. To go on.
I'm sorry to keep interrupting you, but
No.
Before you change gears here, the state filed a series of cases from the 11th Circuit Court of Appeals as supplemental authorities after the course of briefing concluded. If you would take a moment and, what is your argument in regards to, obviously they're not controlling authority, but at most persuasive authority. Has the 11th Circuit defined the sort of implied license case law the same way that we have? Are the facts of those cases that were filed by the state comparable, analogous to this circumstance? How do you respond to the state filing those?
Yes, Your Honor. My impression from reading the 11th Circuit cases are that they actually do not even comply with United States Supreme Court precedent on these issues. Walker certainly would not hold up after Collins v. Virginia. Walker holds that entering the carport to conduct a knock and talk, the 11th Circuit there said that's just a minor departure and that's okay. I think that Jardine and certainly Collins would prohibit that altogether. The carport is part of the curtilage. The police cannot enter. There's no minor departure exception under Jardine, and certainly the carport is off limits under Collins. The Taylor case, in that situation, that is clearly factually different. There was a 911 call. There were a couple of 911 call, or a 911 call, and then the 911 operator called the homeowner back, and there were multiple hangups. So there was a concern, at least there, about the safety of someone. And then when the officers arrived, they did take the the correct path, the implied invited path up to the front door. And then when the homeowner came out from around the side of the house and the dogs approached the police officers turned and walked toward him. It's not even clear from that opinion what else they did that might have deviated from the implied license. They just went, and as the homeowner approached them, they went to talk to the homeowner. And then Ratcliffe, which of course is a district court case, in that situation, that case actually didn't even have to do with the implied license. That's on a separate issue of whether the separate knock and talk or the separate investigation at the front door was a knock and talk. But I definitely think both of those the first case would definitely just not hold up if the Supreme Court were to consider it. And the second one is sufficiently different from the facts here that I don't think that it's persuasive in this situation.
Excuse me, does it make a difference here where they're walking along the right of way and then cut through the yard? Does it make a difference if there's no sidewalks and there's no plantings, no shrubbery to delineate the curtilage?
When you say no shrubbery, do you mean along the front of the yard, Your Honor?
Yes, such basically making a fence out of the shrubbery.
So I think, Your Honor, that I think from the photo and even from the officer's description of Mr. Fall's yard, it's clear what constitutes Mr. Fall's yard. There were trees and shrubbery along the property line between his house and the church where the officers parked. And then the officers themselves stated that they were walking along the right of way along the highway. So they knew where Mr. Fall's curtilage began. And there's no argument anywhere that they didn't cross through the curtilage to reach him. Does that answer your question?
Well, it does. I guess my concern is if, in Jardine, Jardine seems to say that the implicit license typically permits the visitor to enter up the driveway and then take the sidewalk to the front door, which implies to me that there might be times when a deviation is acceptable and lawful. So doesn't it imply to you that you can lawfully deviate sometimes as a law enforcement officer?
I think it's what I would say is that the implied license is evident and depends on the circumstances. And so I think there are circumstances where the implied invitation may be something other than to the front door. So for example, our North Carolina Supreme Court held in Grice that when the front door was obstructed, it was covered over and it was blocked by plastic, and it appeared that everyone would approach the home from the side door, that in that case, the implied invitation was to the side door. I would say in that situation, it's not a deviation. It's just based on the circumstances, what does the implied invitation allow a member of the public to do? In this situation, that's not a factor because it's obvious what the implied invitation was to a member of the public here. And again, there was uniform agreement at the hearing about what that was. It was to go up the driveway, to the sidewalk, and to the door.
Will a no trespassing sign effectively revoke the implied license?
I'm sorry, Your Honor, I didn't hear your question.
Will a no trespassing sign, such as the defendant have here, will that effectively revoke the implied license?
Well, Your Honor, I think our case law says that a no trespassing sign alone does not revoke the license. I do think, however, though, the fact that Mr. Falls had a no trespassing sign in his yard is one circumstance relevant to what the scope of the license is that he intends to extend to the public. I certainly think, we have plenty of case law that says that alone is not enough to say, don't come on my property, but it is one relevant circumstance about whether or not, certainly whether there's any implied license for anyone to do something other than come up Mr. Falls' driveway and up his sidewalk to the front door.
So follow-up question in regards to that. My appreciation from the motion to suppress hearing and also from watching the body cams is that you briefly see the sign in passing, but the officers, I believe at least two of the three of them, if not all three of them, said I don't remember seeing that sign as we were headed to the call. How does that impact our analysis? What are we to make of the testimony that the law enforcement officers did not, seem to have crossed paths with it, but did not appreciate it as a no trespassing?
Yes, Your Honor. So again, what the no trespassing sign has to do with is how does it affect the extent or the scope of the license, and whether the homeowner intends to extend it. I think the police can't just say, oh, well, we just didn't see this. Let's say there were 6 no trespassing signs. Well, we just didn't see them. And therefore the implied license, here clearly, there was no intention to revoke it because we didn't see it, right? It's not the officer's subjective perception of the implied license. It's what the homeowner intended to extend as an invitation. Arguably, if the officers had approached at a reasonable hour in the daytime and had not been in such a hurry to prevent Mr. Falls from leaving when he was trying to depart his own private home, they very well might have seen the no trespassing sign and been able to take that into account in deciding whether or not they actually did have an implied invitation to approach his door and knock.
Was it typical for, is there any testimony about whether it was typical for knock and talks for these officers to conduct knock and talks at night at 9:30 in the evening? Do you recollect?
If I recall, I believe the officers said that, I am not totally sure, Your Honor. I was going to say, I think they said that they do their investigations at all times of day, but they had gotten this tip the day before. So they certainly had plenty of time before that they could have done this knock and talk without waiting until 9:30 on a Saturday night.
Ms. Hitchcock, it looks like you're into your rebuttal time. You can continue. I just want you to know that.
Thank you, Your Honor. Unless there are further questions, I'll save the remaining time for rebuttal.
Thank you.
Thank you.
Mr. Webster, you may proceed.
Thank you, Judge Zachary. May it please the court, I'm Dean Webster from the Wake County Bar, represent the state of North Carolina. I'm in the Attorney General's office. The United States versus Walker case is amazingly on point for this case. It involved officers intending to conduct a knock and talk at the house, are following what would be analogous to this case as the typical path to the front door. But then the officers observe the defendant in a vehicle. This was not on the typical path to conduct a knock and talk. The officers approached that vehicle and thereby deviated from that path. And the 11th Circuit held that that was not a trespass. It was not a search. It was within the canvasser's license.
Sorry to interrupt you right off the bat.
Yes. Mm-hmm.
Mr. Webster, isn't Walker distinguishable from the jump? In Walker, they started up walking up the right path, the invited path. And then when they see someone in the carport, they make a deviation. But in this case, I know that they found that they were walking, in an invited path, seemingly. But I don't know that I see any evidence that actually supports that in the record. I appreciate Walker as being distinguishable immediately from the current controversy.
Your Honor, I think the two are analogous and not distinguishable for the following reason, and I'm getting on the point that you specifically just now made, which was that the officers in Walker began on the right path when they conducted their deviation. That's exactly what happened here. The officers were on the correct path when they did their deviation. They were on the right-of-way, and it was at that point that the officers crossed into the curtilage and conducted the deviation. So the two situations are identical in that respect.
Can you square what you just said about being on the right path with the testimony that from Officer Padgett on page 74 of the transcript, where he says the sidewalk would be what anybody that was going door to door selling anything would take. They would go up the little sidewalk that juts off the driveway. That seems to be, I suffice it to say, have struggled squaring that testimony. And also the trial court essentially makes the same point as well on pages 104 and 105 of the motion to suppress transcript, saying the Girl Scouts would have walked down the driveway to the sidewalk to the front door. That seems to me to be entirely distinguishable and undermine the argument that you're making about them cutting across the front yard being the understood invited path.
I have a diagram I'll show you. I'm not sure how it'll work. If it doesn't work, I'll abandon it. But the moment I'm referring to at the time of the deviation was when the officers are here along the right of way, and then they cut through towards the vehicle. At that moment, the officers are still on the correct path. No, they have not yet gotten to the driveway yet, but that's because it's at an earlier point in time at which the propriety of the cut through kicked in, which is the officers are still on the portion of the correct path, which was walking along, I think it's Park Drive Road or something like that. So again, Judge Brooke, I don't think that you look at it from the standpoint of some later phase of the correct path. You look at it from the standpoint of where were the officers at the moment the deviation occurred. And at that moment, the officers were on the correct path. They were on the right of way of the road.
Point to the testimony or evidence that establishes or suggests that that's the path that would be used by an implied invitee. You point me to that in the record.
Well, I'm not able to point it out right now, but my overall impression from the order and the record was that everyone said that you would take the road to get to the property. And just as a matter of common sense, the very first step in getting to the front door is to take the street that the property abuts. So that's got to be the correct path.
And just to clarify, Mr. Webster, there is no sidewalk on the road, at the road.
That's correct. There's a sidewalk that juts off perpendicular at a later point along the driveway and then goes to the house. But there is not one leading from the road to the driveway. And so therefore the path is, you take the typical path would have been the road to the driveway, then to the sidewalk, then to the front door.
So the Girl Scouts that Judge Brooke mentioned would be required at some point to either walk on the road or in the right of way to approach the driveway.
That's correct. Okay. And what happened in this instance was the departure occurred, the minor departure identical to that happened in Walker, because the officers saw the defendant in his vehicle. And any reasonable canvasser at that circumstance would have done the same cut through to approach the vehicle to ensure that you're able to engage with the defendant while he is pulling out, It's a very minor departure. They went straight to the vehicle. They didn't snoop around or go on a fishing expedition.
Let's zoom out contextually a little bit to talk about the broader context beyond the path here. And I'm using the language from note 2 of Jardine. So this is Justice Scalia's opinion in Jardine, note 2. Do you think it would be customary, usual, reasonable, respectful, ordinary, typical, and non-alarming for Girl Scouts to approach a house in the middle of December at 9:30 on a Saturday evening to sell Girl Scout cookies coming out of the trees, 3 of them? Do you think that would be customary, usual, reasonable, respectful, ordinary, typical, non-alarming?
Yes, it would be within the terms of what the case law indicates is the canvasser's license. And note, for example, that in the
but I want to make sure I understand. You think it's usual for Girl Scouts to come to your front door to sell cookies Saturday at 9:30 at night in the middle of December? That's what you're saying, correct?
Yes, and I mean, another way of saying it is it's not unreasonable. It's not a trespass. It might be,
but it's also, but again, the language here, and I'm using the language from Justice Scalia, is he does say reasonable, but he also says customary, usual, respectful, ordinary, typical, non-alarming. So it checks all of those. The Girl Scout hypothetical, Saturday 9:30, December 16th, Saturday 9:30 at night. It's all of those things. It's not only reasonable, but it's also customary, usual, respectful, ordinary, typical, and non-alarming in your opinion.
Yeah, I say yes. Again, it is reasonable, and also the Girl Scouts are not the only example. We've discussed the pressure washer. What about someone saying, "Hey, I want you to change to my cellular plan or my cable TV plan or my internet plan. Hey, may I have $1 for a sandwich, but really for a beer? Hey, I'd like you to donate to us or sign this petition or this. Excuse me, sir, could you tell me where the Smiths live? Or where is Main Street?" All of those kinds of circumstances, maybe better to do it in broad daylight, but it's within the bounds of reason for that kind of approach to be made. And merely that someone is ambitious in their approach and uninhibited in their approach, as long as it's not done in a threatening manner or anything like that, then it's within the realm of reason. And I'd like to point out too, Your Honor, in the Michigan case, People versus Frederick, there was evidence, which there is not here. There was evidence in that case of these alarming factors. There was testimony from several witnesses that they thought that there must be some kind of emergency and that they were alarmed. And there was even testimony by, I think, a couple of witnesses that they thought about grabbing a weapon to address the approach of the officers. So
Officer Padgett at the suppression hearing, this is page 52 of the suppression hearing transcript, said, quote, "We usually do knock and talks during the daylight hours." Does that factor in your analysis about whether this was customary such that it fits within the implicit invitation?
If it factors in, it does so minimally. The fact that it's 51% of the time, maybe you do it during the daylight, does not rule out doing it at night the other 49% of the time.
So what would you point me to in the record to say that this is, typical standard procedure either for law enforcement officers or more broadly typical standard procedure for a licensee? Where should I go in the record to see that?
I don't know that the record really has much in the way of what is typical or normal. I think to some extent it appears to be addressed as a matter of law that's understood, as in Walker and Taylor, that it's acceptable for approaches to be made in the period of time from something like 7 a.m. to 10 p.m. And in fact, there is a case that distinguished the People versus Frederick case on that basis. It's a Michigan U.S. District Court case. If you shepherdize it, you can see it. But it's I think kind of it looks like it's something in the nature of a matter of law, especially if there's nothing in the record on the subject. And there's nothing either way in this instance, except for, and this is, I think, extremely important, and we're now talking about the time of day, that the defendant was not in his house. He was not retreated into the protective sanctuary.
But he was in it. You would grant he was in the curtilage of his house, right?
Yes, but the key that we're focusing on.
Let me stop you there.
Yes.
For Fourth Amendment purposes, in this inquiry, the curtilage. My understanding is that the curtilage and the house are indistinguishable legally. Is that right?
I accept that. Yeah.
Okay. So how does it matter to our inquiry that he was in his driveway versus his house?
Because what I'm addressing is not so much the space issue, but the time issue. And the space issue means that he is not cloaking himself with, I have retired for the evening. I am in my sanctuary. Do not disturb me. The defendant is out in plain view, getting ready to drive somewhere, with marijuana odor, by the way, emanating from his vehicle. So those kinds of factors militate against the notion that he can complain about the time of the approach.
So
Similarly,
I want to ask you a question about that. And I'm, probably going to indulge in a very lengthy hypothetical here, Mr. Webster. So I apologize for that in advance. Judge Zachary and Judge Berger know me well enough to know that this is not surprising that I do that. But on page 9 of your brief, you say, first assume for the sake of argument that the officers' cut-through presence in the front yard as they approached the discovery location was unlawful. That unlawfulness would nonetheless be unavailing because the discovery of the challenged in-vehicle evidence did not occur while the officers occupied any such unlawful space in the front yard. What I gather from that argument, and I understand the assuming arguendo argument that you're making there, you're not granting that they were unlawfully in the front yard, but what you're saying is they certainly had a right to be in the driveway. And that's all that matters to the inquiry, is that they ultimately made the discovery in a place where they were permitted to be. Is that a fair distillation of your argument on page 9?
Your Honor, I think it is, but I really don't want to stress that argument as much as the fact that the path taken by the officers, including the cut-through, were all within the canvasser's license.
Sure, and because my hypothetical does push on that some, because, I read that hypothetical as, so if I'm a defendant, I'm inside for the evening. I, have to a certain extent retired, Mr. Webster, inside my domain. And it's Saturday, in this hypothetical, it's Saturday at 1 a.m. And officers come up to my back door in my basement, and I'm watching something loud on TV. They knock on the back door, I don't hear them. And obviously this hypothetical is far afield from what we're talking about here, but I want to see if you're going to stand by the point you're making on page 9. Officers find that the door is open. They walk up the stairs from the basement. I, the defendant, am alarmed by this, but I'm also smoking marijuana on the sofa. I walk out my front door to my car because I believe that I'm the subject of a home invasion. And the officers follow me out the front door to the driveway, which is the invited path in this hypothetical. At that point, they see or smell or both that I have marijuana on my person. My understanding of page 9 is the fact that the officers have entered my house. I file a motion to suppress based on the marijuana charges that arise from this hypothetical. My understanding based on your argument from page 9 is that I lose that motion to suppress despite the fact that there was in that instance an unwarranted home invasion, because ultimately the discovery of the illegal activity occurred in a place where the officers via the invited license had the right to be. Am I right about that?
Your Honor, I hope I understood your hypothetical correctly.
And again, I apologize. It's a very long hypothetical. But so the granular point is,
yes.
I think on page 9, what you're saying is all we focus is on where the discovery occurred. Nothing that precedes the discovery occurred.
Yes, and Your Honor, I don't want to emphasize that argument because I can envision a circumstance in which if that position were achieved by a Fourth Amendment violation, then there could be a problem, such as if the officers actually did see no trespassing signs and crossed over a moat with alligators in it and climbed over a fence to then eventually get to the point where they would have been if they had taken the correct route. I can see that there's a problem with that.
So
what I want to focus.
So the gloss that I understand you making there, and I think I
Yeah.
appreciate this gloss, is essentially that there's some sort of, that in my hypothetical, that's beyond the pale, because there's 3 officers in my house without a warrant at that point. But there's some sort of de minimis invasion of the home or curtilage that is permissible so long as the discovery occurs in a place where the law enforcement officers have a right to be per the invited license. Is that a fair distillation of your argument? And if so, can you point me to case law beyond the 11th Circuit? I understand your 11th Circuit case law that supports that.
Your Honor, I think that is a pretty good synopsis of much of my argument. And as to other case law, I was pretty happy to have even found the 11th Circuit case law because it's a fairly esoteric question. And the rationale that the state had arrived upon is that it's within the canvasser's license to make a minor departure when the object of your being there in the first place happens to be out in the open in a car and you see the person. There's no need to take the rote course that you would have taken to do a knock and talk, because you've shifted objectives. It's now not a knock and talk, at least for the immediate future. It's to go contact the individual. So that was the rationale. I had not found any case law specifically addressing that, but lo and behold, later, after what the obvious rationale was, we find the Walker and the Taylor cases, which show that other courts have agreed with that and adopted that same rationale. And while I'm thinking about it, on the time issue, there's sort of like a spatial deviation question, and then there's a time of day deviation. But I want to just say a couple of things about the time of day deviation, and that is, it seems that the defendant is not complaining about the time of day were there to have just been the knock and talk. And because I just don't understand that argument as having been made, which is to say, if the officers had just done a knock and talk and followed the usual route that we've been talking about, there would not have been a problem. And I say from that you extract.
Let me press on that
Yeah.
just a little bit, because I asked opposing counsel a similar question about this. So I gather from what you just said that you think a knock and talk could have occurred 5 hours later into December 17th in this occasion at 2:30 a.m. in the morning. A permissible knock and talk could have had same facts as here. And same outcome that you're advocating for. It's the only thing that we change is instead of this occurring December 16th at 9:30 p.m., it happened December 17th at 2:30 a.m.
I have not made that contention, Your Honor, but I have noted that the Walker case and the Taylor cases involved something like those. One of them involved 5:04 a.m. and I don't recall the other one, but anyway.
And Mr. Webster, I do want to press on this point, and I'm not trying to be gratuitous and difficult here, but would you say that this was a knock and talk if it had occurred December 17th, a permissible knock and talk, December 17th at 2:30 a.m.? And I think that lends itself to a yes or no answer that you can then explain.
I think the answer is I don't know, because it's a different circumstance that I have not addressed really. Though I note that one of these cases in our supplemental memorandum, one of them involved at 11 o'clock p.m. time.
That seems to shade towards you perhaps suggesting that it is a knock and talk if it happens at 2:30 a.m.
Well, as has been mentioned, there are factors which might legitimate some in the middle of the night approaches and not others.
So timing is relevant, but not dispositive.
That may be, and it does seem like there's some mention of that in either footnotes or whatever of some of the U.S. Supreme Court cases. The People versus Frederick case is couched as having been in the middle of the night, which is not what we have in our case.
You agree, I assume, and you can disagree if you'd like, but you agree that it's unlikely that the Girl Scouts or pressure washers or the UPS guy is going to be seeking my signature at 2:30 a.m. as opposed to 2:30 p.m., right?
I think that's a lot less likely.
Yeah. Okay.
But 9:30 a.m., excuse me, 9:30 p.m. is not problematic. And again, it may be ambitious, but it's not. It doesn't rise to the level of being so intrusive that it constitutes a trespass. And significantly, you can see from the reaction of the defendant that he doesn't treat it as having been alarming or anything. He's got his window down and he engages freely with the officers. He's not acting as if he's bothered at the initial instance about the approach.
The officers in the motion to suppress hearing characterize him repeatedly as being belligerent and saying that he had, and watching the body camera footage, he repeatedly says they have no right to be there. So I think the officers have a different reaction to how the defendant reacted here than you did.
The evidence, Your Honor, shows, and what the key time is, the time of the approach and the time when the incriminating evidence from the vehicle is discovered. Up to that point, the defendant shows nothing but receptivity to the officers. It's only after the incriminating evidence is discovered that he starts having some difficulties. But that's not the point you look at. You look at what is it that the officers were confronted with as they approached, and they are confronted with a vehicle pulling out with the window down, and the defendant saying, "Hey, what's up?" So, of course, it's okay to engage in that circumstance, and it's not an alarming, intrusive, violative trespass. Those, I think, are my primary points. If I let me see if I see a couple of other things. Oh yes, let me take go back to my diagram just really quickly, and I hope you can see it. Okay, let's see. My point here is that it seems that the engaging with the defendant was going to occur whether they had stayed on the correct path or not. And the top of the diagram is, we'll say this is at 0 seconds when the officers are still on the street and the car is just starting to back up. Then let's just say at about 0.5 seconds later, the officers have moved a little closer to the driveway. The vehicle is backed up a little further in the driveway. This is still with the officers remaining on the correct path. And then at about 1 second total, the officers would have reached the interface between the road and the driveway, and we would have had the defendant probably reaching that same spot, and they would have been right at his window to observe what they observed up here. So in some ways, this is much ado about nothing, but at any rate, I see I'm down to 30 seconds. The officers were within the canvasser's license. The circumstances did not invalidate it. I do appreciate how familiar you all are with the law and the facts, and I request that you affirm the trial court's denial of the motion to suppress. Thank you.
Judge Berger, do you have any further questions?
No.
Judge Brooke?
No, thank you.
Thank you, Mr. Webster. Ms. Hitchcock, you can proceed with your rebuttal. Ms. Hitchcock, you're muted.
I see. Thank you. So, Your Honor, to start first with the state's last argument, where the state argued that the police would have reached the defendant anyway. First of all, there's no evidence in the hearing that that is the case. The state did not even attempt to show at the hearing that had the officers not cut across the yard, that they would have been able to engage with Mr. Falls anyway. And in fact, the trial court even seemed to acknowledge that that was not the case and said, the court observed the officers could have let the driver of the car go, gone back to talk to him another time, but said, it seems like it would be better to just go walk over to the car and see what he had to say. So without the trespass, the officers do not reach Mr. Falls, and there's no evidence to show otherwise. Second, we don't concede that the 9:30 p.m. on Saturday night is reasonable for any purpose. Again, a UPS driver is a very specific, defined purpose, and a delivery that has to be made with a signature is different than officers who are trying to approach to ask for information. Thank you, Judge Brooke, for pointing out to me that there was testimony that these officers usually do conduct these during the day. I was confusing it with a case that I had read, but in any event, you have to consider all of those.
Sorry to interrupt. Is that fact in the record pertinent to our inquiry, something that we should consider as part of our inquiry, that these Macintoshes typically did happen in the day?
I mean, I think it is important, Your Honor, but I think what's more important is just to consider, I think it is important because I think it's an acknowledgement by the officers that typically that's what the implied license allows. Another important thing that I want to emphasize is that Mr. Falls' conduct here is completely irrelevant to what happened. The fact that Mr. Falls didn't immediately started shouting at 3 police officers who surrounded his car when they approached him has no impact on whether the officers did or did not violate the implied license. Again, his conduct is irrelevant here. Another point that I want to make is that, and I started to get this towards the end of my opening argument, is that there's not a de minimis exception to the protection of the curtilage, Your Honor. And the state has now backed off on its argument, but I had the same impression from its brief, which is that it's asking this court to make a huge exception to the protection of the curtilage, and to say that as long as the officers end up on the path of the implied license, then it matters not at all how they got there, and that they can then proceed to conduct their knock and talk or to seize or, see whatever they see in plain view. And that obviously is exactly what the Jardine court was worried about, that they have to circumscribe the knock and talk doctrine in order to prevent the protection of the curtilage from being swallowed altogether. And the last thing that I want to say is to go right back to what you said, Judge Brooke, about Note 2 in Jardine, because it's a really important observation. Because both the majority and the dissent in Jardine agree that the implied license is about the appearance of the thing, right? It inquires into the appearance of things. And the reason that the Girl Scout example is given is because it is an easy rule for officers to follow. The reason that we say Girl Scouts manage this without any trouble is because police officers should also be able to manage this without any trouble. The curtilage is the curtilage, and when the officers enter the curtilage for the purpose of acquiring information, a Fourth Amendment search occurs, and they can only do that if they have followed the implied license. And finally, in thinking about what is ordinary versus alarming, I just ask Your Honors to imagine that you yourself on Saturday night at 9:30 discover that you are out of milk for your Sunday morning coffee. This has happened to me. And you step outside, you get in your car, you're backing out, and all of a sudden out of your trees in the dark of your yard come 3 darkly clothed people shining a flashlight in your face and surround your vehicle. You're going to want to get help at that point. And that is the primary thing that shows that what happened here was outside the scope of the implied license. Mr. Falls respectfully requests that you reverse the denial of his motion to suppress and vacate his guilty plea. Thank you, Your Honors.
Thank you. Judge Berger, do you have any further questions?
No.
Judge Brooke?
No, thank you, Judge Eckert.
Thank you, Ms. Hitchcock.
Thank you, Your Honor.
That concludes oral argument in this matter. Thank you both for excellent argument and for participating in this today. Mr. Shore, we may adjourn.
This session of the North Carolina Court of Appeals is now adjourned.
Y'all, good to see you.
Thank you.